We now turn to Chapter 7 of your casebook, which deals with liability insurance and specifically the questions of defense, settlement, and excess coverage. Liability insurance, as we've already seen, frequently deals with the problem of indemnification. In this chapter, Chapter 7, we focus more on the lawyer's role and the actual litigation and settlement of liability insurance issues. We talk a lot about the scope of the duty to defend, what the duty to defend involves, and when it's properly invoked. We will be introduced to the reservation of rights letter and the use of the ROR letter as a mechanism for protecting the insurance company. We'll deal with a couple of cases in which there are conflicts for lawyers and talk a little bit about noisy and quiet withdrawals by lawyers in the event of a conflict. We will also deal with the question of the duty to settle and what the appropriate time is for settling as opposed to litigating. We'll deal with the reasonable offer test and look at whether or not that helps in evaluating settlement offers. And we'll also take a look at the way that excess carriers interact with primary carriers and specifically look at a case of drop-down liability. Most liability insurance policies contain provisions providing for indemnification of the insured as well as defense of the insured. We're going to be focusing in this chapter on the defense of the insured for the most part. Defense insurance is sometimes called litigation insurance, and one of the key things to remember as we begin looking at this material is that in general the duty to defend is broader than the duty to indemnify. And as we start looking at some of these cases, you'll see how that plays out. But basically what that means is that the duty to defend is triggered much more easily than an obligation to actually indemnify an insured.